Good morning and good evening to our online participants. Welcome you all to today's webinar on digital trade and Indo-Pacific Economic Framework. My name is Nong Hong. I'm the Executive Director of the Institute for China and American Studies. We are an independent think tank based here in Washington, D.C., focused on many of the key issues affecting the U.S.-China relations that actually need a lot of greater mutual understanding. This webinar is a part of a series of events of ICAS Trade and Technology program. So the goal of our program is to provide a timely analysis on the U.S.-China trade and technology affairs, and also try to expand the public dialogue on many of the issues. Let me just say a few words about why we launched this program today, this event today. The Indo-Pacific Economic Framework was launched May last year as a part of Biden administration's commitment to strengthen its ties with its allies and partners, and also tackling many of the economic issues in Indo-Pacific. And actually in this week, I think already started from the 8th, and US will meet always ongoing with the IPAC partners for the third full negotiation in Singapore. And then on May 27th, and I think the Trade Minister of IPAC states will meet again on the side of APA in Detroit, which is a very good opportunity for the ministers to review the current progress and provide additional direction to the negotiators to advance the progress on the framework, the 4 pillars. And digital trade is certainly one of the most important topics. The rapid development of digital trade has driven the emergence of new formats and models, posing a very high requirements and greater demands on international rules. The development of digital trade is clearly driven by technology development, and there are differences among the countries on the recognition of risks and challenges brought by technological progress, and different states or parties to have different approaches towards balancing development and security on the other hand, and also innovation and regulation. There's also uncertainty regarding the direction of digital trade rules and the effective implementation. So we hope that through today's discussion, we hope to provide some answers or expand the discussion on questions such as what are the key barriers to digital trade and what are the key challenges for facing governance of cross-border data flows at a global level. And we also hope to answer questions such as China's Digital Economic Partnership Agreement session talks. So this panel will be moderated by my colleague, Mr. Saurabh Gupta. He's the Senior Fellow of ICAS. He's also heading ICAS Trade and Technology Program. He has a lot of writing analysis on this topic. And we are very delighted to invite 3 very distinguished speakers to join us today's discussion. You're going to have the full bio on our website's event link. Let me quickly introduce the 3 speakers. We have Professor Susan AARONSON. She's the research professor and director at the Digital Trade and Data Governance Hub at Illinois School of International Affairs at George Washington University. And we have Professor Patrick LeBlanc from CN Tellier Chair on Business and Public Policy from the Graduate School of Public International Affairs, University of Ottawa. And we have Mr. Zennon KAPRON. He's the founder and director of Kapronasia, which is one of Asia's leading provider of consulting service focused on the fintech industries. So without further ado, let me pass the floor to my colleague, Sarah. You have the floor.
Thank you, Nong. Good morning, good evening to everybody. Welcome to our program on digital trade and the Indo-Pacific Economic Framework, new rules, new opportunities, new challenges. As moderator, let me provide just a very bare bones table setter of our conversation. This conversation is about digital trade and cross-border data flows in the context of the Indo-Pacific Economic Framework negotiations. A little bit about IPEF. IPEF, there's going to be a ministerial later this month in Detroit. I think it's May 27th. This year's IPEF is shaping up to be in ways let me frame it this way. United States Trade Representative is this year is the chair of the APEC group. And just as it had done in 2011, which was the third year of the previous Democratic administration, the Obama administration, it had used its chairmanship of APEC to also push forward on, at that time, the TPP negotiations as the host of the TPP, as the brainchild in a way of the TPP, although of course Singapore, Brunei, and Chile may take credit for that. And what essentially happened was, because the TPP folks were a subset of the APEC countries, the goal was to move the ball forward as far as possible on TPP. And of course, APEC was the primary area of discussion, just as it is this year too. But APEC, since most of the IPEF countries are also represented within APEC, the APEC ministerial essentially is also going to double. At the end of the APEC ministerial, we're going to have the IPEF trade ministerial. And the hope is that to push the ball forward as far as possible, so that by the time of the leaders summit of the APEC countries, there will also be a leaders meeting of the IPEF countries in San Francisco. Now, again, in 2011, the same thing happened. And that time, the Obama administration hosted its APEC Leaders Summit in Honolulu. And yes, they did move the ball forward on TPP, but they could only move it so far. And as we know, the real negotiations in TPP happened in the last 2 years of the second Obama administration. But anyway, the same kind of same modus operandi is being utilized by USTR this time around too. A little bit about digital trade out here. The IPEF negotiations, USTR is calling it as a new type of trade agreement, et cetera, and there's a fair degree of vagueness as to just exactly how it's going about it and the end goals. The digital trade chapter is, in fact, one of the most politically contentious aspects of the IPEF negotiations, and could potentially be one of the most promising too. It's also become fairly controversial, and we've seen that in recent days, particularly in the US, where we've had kind of progressive senators and progressive congressmen and congresswomen talking in terms of that this should not be a sellout or a giveaway to corporate interests, because previous digital trade agreements that the US has signed, or digital trade chapters, have been kind of seen in that light. But at the same time, we've had pushback from, say, the US Chamber of Commerce, suggesting that, we should not be using the digital trade text in the IPEF negotiations as a backdoor route to do things like competition policy in the United States, and that needs to be done through domestic regulation and not via an intergovernmental agreement. But out here also there's a degree of difference. And this was encapsulated in the fact that there were certain Republican congressmen who shot out a letter just last week saying that, hey, back off a little bit in terms of telling USTR that, we Republican congressmen are trying to pass legislation on competition policy, on intermediary liability, on speech censorship, and those sort of issues. And it's not USTR's job to get ahead of us and have rules in that regard before we have made those rules domestically. And so the main point I'm trying to get at out here is that USTR is trying to create Asia-Pacific-wide digital trade rules, but domestic regulation is itself in flux. And is it possible to set in stone those rules, particularly when there is so much flux in domestic legislation? And the US is understood to be a little bit behind, frankly, in terms of having federal laws in the area of privacy, in trying to do antitrust competition policy on an ex-ante basis rather than an ex-post basis. And so while the Chinese and the EU have moved forward in that regard, and the US is perhaps trying to, or the Biden administration is trying to copy some elements of the EU's approach. So this is all setting up, I think, for a very good discussion, because it is this intersection of geopolitics, international trade, and domestic regulation all encapsulated together. on an important topic, which even countries say like China, which is outside the negotiation, is watching fairly closely to understand where these matters are going forward. Let me stop out here and let me throw the floor open to our first panelists. Susan, if you can, the floor is yours. Please go ahead with your prepared remarks. Thank you.
Well, I don't really have prepared remarks because I think it's very difficult to do an assessment of something that is not transparent and is only spoken about in vague generalities. Basically, I would like to begin by saying that the United States is in a catch-22. On one hand, we really need to have modernized trade agreements that open up markets, but also protect workers and communities from harm. And to their credit, the Biden administration has been trying to come up with such an agreement, right, with allies that have similar quote unquote values. And so the key ally in that regard is India. But India is a country who has talked about digital sovereignty and who is also very adept at data-driven services, but believes that that data should not be moved from the country, should not be controlled by entities from outside the country. So unless you have some sort of binding common ground, anything that you come up with India, Singapore, Australia, Japan, etc., could be very interesting, but is unlikely to have much force. And so that's part one of the catch-22, right? Meanwhile, Congress, as you know, in the United States is a freak, as I always teach my students, in that the responsibility for trade policy is shared between the Congress and the executive branch. And usually the executive branch says, this is a country or countries I'd like to negotiate with. And the Congress sets out the principles and objectives of trade policy. And the Congress has not agreed to normal trade relations, something Saurabh and I used to work on together. and is very unlikely to do so. So another reason why the United States is moving in this sort of aspirational framework model is to bypass Congress. So here, we're caught in this catch-22. I find it very worrisome. It is dishonest, it is opaque, it is unfortunate, and it is worthless, frankly. So sorry to be so opinionated, but, and I probably shouldn't have gone first in that regard, but I really think the United States is hemming itself in. That's the catch-22. I get it. We cannot move forward with Congress. Congress is full of Republicans who don't want to see Biden have any success. Even there have been many who have suggested the United States rejoin CPTPP, which is, in my mind, quite primitive in terms of its digital trade provisions. And we can't even do that. So we are hamstrung, and that is quite unfortunate. I want to make another point, and then I'll shut up for now, which is the U.S. provisions that we know of, and again, that is in a trade agreement which trades market access for binding and disputable provisions in general, right? It's not worthwhile if you can't make it binding and disputable. Sorry to be so opinionated. The reason that that's important is that many of these provisions are built on exceptions. So for example, source code. On one hand, if you can see an algorithm, you can try to explain it, and that might allow people to understand how decisions were made, let's say by a bank which rejects a loan, or a government which uses AI to decide who to hire. Okay. So a government may say, we'd like to see that algorithm, and it may use, because the United States views that as a performance requirement, these are built on exceptions. So essentially the United States is saying, if you want us to do this, we can do so, but you have to have a legitimate reason to do so. And so one reason could be to protect public safety, right? So using this as an example, it is a barrier to explainable or trustworthy AI. Other provisions that are totally out of date include, first of all, most of the existing US agreements say nothing explicit about sharing data. And if you study AI, as I do, I'm a co-PI at the NSF Trustworthy AI Institute, where I look at the relationship between trade agreements and AI. You will see that other countries have done more. Admittedly, and a perfect example of that would be Singapore, UK, which is the most recent trade agreement that discusses these issues. So the United States, the country that has more AI companies, more than any other, is unable to come up with regulations to govern the free flow of data that underpins many forms of AI. So that is the catch-22. And again, having a framework model could be helpful, but it is unlikely to set precedents. It is unlikely to succeed. And that's why I'm so negative about it. So sorry. Thanks for hearing me out.
Thanks, Susan. Yeah, that's helpful. You talked about that aspirational framework model because, just I think last week, 2 weeks back, the National Security Advisor put out a speech and where he talked about international economic policy. But I mean, that sounded like a mishmash between what Peter Navarro would say and a little bit of what Janet Yellen said last year about French shoring and what Catherine Tai is speaking on terms of new trade agreements, which is not exactly clear. And so where are we landing up with all this, and what is specific about it?
Well, it's interesting to see where Canada is going with this, but that's a different point. But the notion of, so what this is based on the notion that China is a strategic competitor of the United States, and China has accepted that view as well. You see Chinese officials. It's actually funny that you're asking me about this because I'm just writing on it. So how do you explain this strange relationship between the United States and China? And I think it starts really in 2014 when the US accused China of cyber theft. And of course, around that same time, you had Made in China 2025. And at that time, China said, senior Chinese officials and Premier Xi has often talked about the data-driven economy and how he believes that this is going to transform China and it's a good thing. And you see China really moving in these directions of stimulating data-driven economy. And the United States sees the cyber theft plus this plan. And the United States is no good at coming up with a strategy and governance structures to address these things. And that's where I think you see this roots of the strategic competition. Unfortunately, the Trump administration legitimated this kind of vision of China. And I'm very opposed to a black and white perspective because we really have to work with China. As someone who teaches at a university, we need Chinese students. Google needs Chinese competitors to keep it on its toes. It's a lumbering giant. Now, the same is true with WeChat and every other Chinese data giant, but this situation is so worrisome. How do you deal with it diplomatically? I don't think the answer is to try to pit in an aspirational framework India plus Japan plus Australia against China. I don't think that's good, but do I have a better way? No.
Thanks, Susan. That's helpful. We'll come to this discussion of where US and China and their rival approaches, including in the data sphere with the DEPA and all those, where China is going with that. Let me turn to Patrick LeBlanc next for his views on this subject. Patrick, the floor is yours.
Yeah, thank you, Saurabh, and thank you, Susan, for setting the tone for this discussion. I do share many of her concerns, although maybe I'm less pessimistic in terms of some kind of agreement emerging out of the framework, mostly because in a way, the way I see things evolving, and I'll get to that, in terms of digital trade, it seems that the United States, which is leading this, is really trying to accommodate kind of everyone's views, which ultimately goes back to the exceptions that Susan was talking about in various agreements, which then allow pretty much a sort of, kind of anything goes kind of approach, which on the other hand completely undermines the effectiveness of these agreements, as Susan mentioned. So to me, the way I look, the way I'm trying to understand what we're likely to see in the Indo-Pacific Economic Framework in terms of digital trade, there are two components. And that's based on basically what I would expect to see is some kind of digital trade agreement or chapter. And I'll talk about that, what that would look like. And then the second element is something that the United States has also been pushing, is the whole idea of the Global Cross-Border Privacy Rules Forum. And these two things are complementary. And I'd expect that in terms of digital trade, governing digital trade within the Indo-Pacific Economic Framework, those would be the two masterpieces, I would think, at the core of this digital trade governance within IPAF. So let me start with the forum, and then I'll go back to what a digital trade chapter or agreement would look like. So the forum, this Global Cross-Border Privacy Rules Forum, is something that was announced last year by Secretary Raimondo, about that the US was launching. And basically the way to understand this is to take out the cross-border privacy rules that have been developed within APAC and move them out in order and have it led by the US. So in a way, excluding China, including obviously a number of Indo-Pacific countries, but also potentially beyond the Asia-Pacific or Indo-Pacific region, and really kind of develop what I see ultimately as sort of an alternative to what, in a way, the European Union has been doing with the GDPR, so the General Data Protection Regulation, in terms of providing a sort of separate kind of data protection privacy framework that would allow for personal data to move across borders. And the idea of this cross-border privacy rules forum is that basically companies are certified in terms of respecting the sort of certain standards that then allow them to move data, personal data, across the members of the forum. At least that's how these rules have been developed within APAC. And the US with this forum seems to kind of continue that same logic, although obviously outside of APEC, where things have not really evolved very much since this was started in the mid-2000s. So, and interestingly enough, I'm looking at my notes here. So yeah, so this forum, the way it works is that that you have principles, and already within this CBRP, the CBPR forum, there's already a framework that has been launched in terms of both governance, so some kind of members assembly that would decide on the rules, potentially whether they would go down to specific standards. That's a big question, but certainly right now guiding principles have been developed. So I actually looked at that, and interestingly, what we can see is a fair amount of leeway. In a way, going back to what Susan was saying, in terms of this global forum framework, you can see that in terms of its implementation, it would respect social, cultural, and other differences among members. So that's already kind of okay. That provides some element of flexibility. Then it also states, and these are from the commentaries aside from the actual article's principles, exceptions are allowed that suit the particular domestic circumstances. And then it says the framework is not intended to impede governmental actions authorized by law when taken to protect national security, public safety, national sovereignty, or achieve other important public policy objectives. So if you read that sentence, to me, it's kind of a, get out of jail free card. You can do whatever you want, as long as you can say that it's, for national security, public safety, or even national sovereignty, which it kind of, it's the opposite of what normally we expect when we have an international agreement. It's to some extent constrain national sovereignty so that, we can trade with each other, we can have the same rules, and what one part, there's a kind of mutual recognition of the rules. But in this case, and we like, no, national security or national sovereignty, this is what we do. You don't like it, your problem, not mine, right? And we've seen this certainly in the context of the WTO. A lot of members, including the United States, are pretty much saying that national security is self-judging. I'm the one who decides what national security is, not you, not an arbitration panel under some kind of dispute settlement mechanism. It's me, the United States, or it's me, Japan, or it's me, China, and because the same language we've seen, for instance, in the sort of leaked text of the WTO work on e-commerce, you kind of see the same language coming. And it's interesting to see that it's reflected in this Global Cross-Border Privacy Rules Forum in a way to accommodate a number of countries, especially you might think, countries that are more, let's say, careful in terms of, or they really want to control their data, maybe the Philippines or and others. Eventually, we expect that countries like India, which Susan mentioned, also would be part of this forum if it becomes the kind of basic framework within the Indo-Pacific Economic Framework. So, as such, you have countries that, in order to accept these rules in a way or these principles, they also say, well, we want to have the exception to do what we want. So ultimately, does it really change anything? So that's the first part where, yes, the US is trying to move to promote its own kind of framework and forum for data protection away from China, possibly in competition with the Europeans, but hoping to have influence there. The other element is what we can expect is a digital trade agreement of some kind, or a digital trade chapter. And there, what I thought I would look at is what the US and Japan agreed to, because the US and Japan have a digital trade agreement that was part of the sort of, we're not going to negotiate a free trade agreement, but let's negotiate these bits and pieces that do not involve Congress. So basically, the Japan and the US agreed to a digital trade agreement, which, if you look at it, is kind of obviously very much inspired by what we see in the e-commerce chapter within the Trans-Pacific Partnership, which should not be a surprise, given that originally both the US and Japan had agreed to this text within the Trans-Pacific Partnership. Obviously, it's been let's say beefed up a little bit because of what the U.S. has kind of put into the USMCA with Canada and Mexico. Some of that language appears that was not in the TPP or in the CPTPP right now. But it's interesting that even in that agreement, the exceptions are coming back in terms of legitimate public policy objective, or pursuing an important public policy objectives when it comes again to cross-border transfer of data or electronic information through electronic means. Again, you see these exceptions which are there in the TPP, are there in the USMCA, although they're more constraining in the USMCA. They're there in the US-Japan digital trade agreement. So ultimately, again, it creates a situation where it's not clear how much these agreements, if they ever come, which I think they will, given the nature of the flexibility of the language, I think we will reach an agreement, which is in one way great. It does create the basis for cooperation and potentially further strengthening the rules down the line. So, you know, one can see it as a first step. But if one expects any kind of agreement to be kind of the free trade or you know, what is it now, the new term that the G7 has come up with, you know, is it data free flow with trust? That's the new slogan that is out there that the G7 digital ministers just agreed to. I don't think we're there yet. Certainly not in terms of free flow. In fact, it's more of a license to continue adopting, in a way, nationally based regulation that might differ with those adopted by other partners. So ultimately for business, because ultimately that's what it's all about, as far as I'm concerned, it's not clear that business will gain very much in terms of having an easier way or easier time flowing data because the standards are going to be the same or there's going to be mutual recognition. Ultimately, they will still have to make sure that when they transfer data, they have to satisfy national regulations that can be quite different from one member state to another, which again, if the goal of the Indo-Pacific Economic Framework is to have, you know, foster inclusive growth, well, that's going to be a big challenge for small and medium-sized enterprises, right? The larger ones, multinational ones, obviously have the means to hire the consultants, the lawyers, to comply with those different rules. But if you're a smaller or medium-sized enterprise, that's much more of a challenge. So in a way, I'm not sure that on the one hand, yes, you get to an agreement. On the other, it's not sure how effective it's going to be at fostering the free flow of data with trust, and at the same time foster inclusive growth. And finally, the issue is that then, you know, I think I saw Stephanie Honey is in attendance on the webinar, and you know, she's been talking about the new, you know, we had the spaghetti bowl that Bhagwati talked about in the 1990s. Now, you know, Stephanie Honey talks about the noodle bowl, right? In a way, we have all these agreements that are coming online. You know, Saurabh, you talked about DIPA, and you know, these digital trade partnership, these digital trade agreements, these digital trade chapters in broader trade agreements. And you know, they're all kind of coming online. There's a lot of overlap in terms of membership, in terms of rules. And I'm just thinking that if you're a business trying to understand where things are going, good luck. I mean, we're all struggling ourselves to kind of keep track of where these things are going. Great in the sense that it fosters cooperation, it fosters dialogue, which is very positive. But right now, I don't see what's happening as kind of an improvement, really in terms of fostering this digital trade itself, and ultimately this data free flow with trust. So I'll stop here. Thank you.
Sarah, you're muted.
I got it. Yeah, thanks, Patrick. That's really helpful. It's essentially about the exception swallowing the rule in terms of in the area of data flows to accommodate national-based legislation. And one would think that, you know, the way the US approached TPP and then the approach to IPEF was at least to have very high standards, kind of cutting edge standards, if nothing else, because to an extent there was that element of excluding China and that China could not attain those standards, and therefore we would go down that route. But the fact is that in IPEF, I don't get any sense that there's anything terribly cutting edge out there, or that it is really setting new standards. And therefore it begs the question, I mean, a lot of effort towards what and what the purpose is. And I think that point comes out very clearly in what you said in terms of exception swallowing the rule to accommodate this, and in the process, maybe USTR might have lost sight of the larger goal that it was trying to move towards by having something like IPEF. So, I mean, if you want to just jump in briefly.
Well, I think it, in a way, it goes back to Susan's catch-22 in a way, right? Because the US is pursuing multiple objectives, and you might say Japan too, and so is the Republic of Korea, which I think are certainly important players in the Indo-Pacific Economic Framework. Is that on the one hand, you're trying to keep China in check in a way, right? And on the other, you're trying to foster more trade, more free flow, higher standards. But obviously within the members, there are huge variations in terms of obviously economic development, but also in terms of what governments are trying to do. I mean, we see, for instance, in India, where the current government has adopted a much more, let's say, controlling approach to the digital economy in a broader sense, and data and all that, and certainly is much more, as we know, skeptical of free trade. So that poses a challenge. But at the same time, if in order to placate China to some extent, you need India. Well, you gotta allow in a way India the exception to be in, right? So that's kind of pursuing, let's say, more of a geopolitical objective, which represents China, at the same time as fostering this kind of data free flow with trust and free trade or free digital trade is almost impossible to reconcile. In a way, this is let's say my version of Susan's catch-22. And really what you see is the United States, whether it's USTR, Department of Commerce, trying to square or in a way circle the square ultimately to make this work. And maybe the way to understand it, and we've seen this in Europe often, is first let's get an agreement in the table. Let's get the parties involved, which then creates a bit of a lock-in, which creates this possibility at least for a dialogue, for exchanging, and then maybe in the future, we can move to higher standards or more stringent standards, right? In a way, as a kind of almost a trust and socializing experience, if you want. So maybe that's the way to make sense of what's going on.
That's really helpful. Thanks a lot. Our third speaker is Zennon KAPRON. Zennon adds a very useful perspective to this conversation because Zennon is based in Singapore. He's on the ground in the private sector, does this every day, and has a sense of what the opportunities are in this space, what the challenges are in this space. And also, perhaps we would have some insight as to I'm sure he's from the private side, and then there are the regulators on the government side. And what is that interaction like in terms of how the regulators want to treat the regulated in an emerging industry, which has great potential, but also has challenges. So I'm looking forward to your comments, Zennon. The floor is yours.
Thanks, Rob, and thanks, Patrick and Susan. Those were, I guess, if anybody's looking to come with a positive, exit the webinar with a positive view of what's happening, you picked the wrong webinar. But I think it's largely, the comments that both of them made were quite apt. Just kind of some broader comments about what we're seeing, and just for background, I've been in Singapore for 5 years, but before Singapore, I lived in China for 14 years. Always focused on financial technology, so very aware of how fintech and digital payments on things like Alipay and WeChat Pay have grown, and the ways that the government enabled that, and then the past couple of years has really tried to constrain that as well. So I have a very firsthand view of what happened in China around those topics. I think when we look at the digital economy in general, including fintech, including cross-border e-commerce and data, this truly is the future for many of these countries for multiple different reasons. For a place like Singapore, I mean, Singapore, a country that is very lacking in terms of natural resources, has always managed to reinvent itself as a services destination, whether that be biotech 15 years ago, tech 10 years ago, and now fintech being one of the key drivers here, and trying to put the institutions in place, both in terms of legal framework, rule of law, education, the structures that are needed to really allow these digital ecosystems to grow. Whereas, just across the border in a place like Indonesia, I mean, Indonesia has hundreds of millions of people, largest country, certainly in Southeast Asia, and then in Asia behind China and India, obviously. They have a separate set of challenges. What is effectively an archipelago of thousands of different islands has challenges around financial inclusion, digital inclusion for that matter. And so, when we look at how countries are looking at regulation around whether it be data or payments or anything, it's very inward looking, firstly. We're seeing that in Southeast Asia, particularly around payments. So here in Singapore, we have what's called Pay Now, or FAST is the real-time payments infrastructure. And this is basically a payment infrastructure that Singapore put in place that allows for real-time payments using QR codes, or just putting somebody's mobile number in your phone, kind of similar to what you'd expect from a Venmo or in the US. And Singapore has that real-time payment system. Indonesia has that. Malaysia has that. Thailand has that. Multiple different countries around ASEAN have their own domestic real-time payment system. In 2000, I believe it was 2008, a website was set up and an organization was set up called the Asia Payments Network. And so the idea was a subset of the ASEAN organization focused on enabling cross-border digital payments. Now, the benefits of cross-border digital payments are manifold. There is quite a bit of intra-regional trade, B2B trade. There's obviously tourism that goes back and forth. There's a large foreign workforce. Here in Singapore in particular, there's quite a few Filipinos and Indonesians that come to work as helpers or maids that are constantly sending money back to their home country. So there's a lot of opportunity within ASEAN to develop this kind of payments framework. Yet, although that organization was set up in 2006, 2007, absolutely nothing has happened in the past 15 years in terms of coming up with a multilateral approach to a payments network. And so basically what we've seen individual countries take it on bilateral basis. So Singapore has an agreement now with Thailand, with India, and with a few other countries such that within those corridors, money can flow back and forth, connected through to the real-time payment systems. And that, that challenge kind of hints at the challenges that we face around a lot of these things in Southeast Asia, which makes me a little bit skeptical of certainly anything happening here on a multilateral basis around data protection or data sovereignty. And is leaving many of these countries to develop their own rules that they're using domestically that are then applying to organizations that come into the country, and thus, as Patrick kind of hinted at, increasing costs for a lot of these players as well. I mean, for a large multinational like a Citibank or an HSBC to go into a place like Indonesia, okay, they have to set up a separate IT system, they have to hold the data domestically. But to a certain extent, they're used to doing that. For SMEs, we even face this as well. And some of the standards that we have to control around user data are not dissimilar from GDPR in terms of the amount of information that we have to collect and the disclosures, the limitations around both of those. So, I think when we look at what's happening on some of these global agreements, I mean, countries like the US need to be seen to be doing something. And moving in a direction, because when you look at AI, when you look at data, this truly is the future. And there has been a lot of amazing commentary, not withstanding just our guests that we have here today, but around the future of AI and what we need to do around regulation. And some people are arguing for it, and some against it. And when you think about coming up with kind of any kind of global regulation around this, if you don't have China involved in it, then it's largely pointless. I mean, in the AI battle, it's clearly the US and China right now that are going head to head. And it's very unlikely that China would agree to any kind of limitation around AI development, especially given the current kind of geopolitical relationship between the US and China at the moment. And so the question then becomes, is it possible, as both Patrick and Susan hinted at kind of pressing reset on that, and how do you do that? And I think that's the big question that I'm curious to hear their thoughts on, because I think Susan did a really good job of pointing out a lot of the challenges. But I think the fact that the experts in the room that we have here today don't have solutions at the top of their minds is an indication of how difficult and intractable the current situation is. Because when you look at some of these things, it truly is the future. And anybody on the call, if you haven't used ChatGPT, you've been living in a cave. But the impact of AI, as we see further iterations and integrations around this, is incredible. And China is not resting on its laurels around this. But I think the challenge is, what can you accomplish? And whilst having something in place is better than having nothing in place, I guess the question comes down to, as Patrick was mentioning, is it actually worth the effort to go through it? if it's going to be a relatively toothless agreement, because I think that's the best that we can hope for, is something that includes either a lot of exceptions or is fairly general with principles without any really deterministic regulation around it. And then, Shorab, just to tie off, I think when you mentioned about regulators and how they're dealing with the industry, I mean, different regulators have different approaches to this, obviously, and you know, Singapore takes a very principles-based approach around certain things like data protection, but it's getting you know, increasingly getting attention in the country, whereas places like Indonesia and China obviously have more stricter domestic policies as well. So I think, you know, the regulators are really looking to the governments and following the government's lead in terms of defining what these look like for the best outcomes for the country. I think, you know, over the COVID period, we went into a very solitary environment where there obviously wasn't a lot of trade and travel that was happening between these countries. And countries really, you know, it was a refresher on what do we need to do to look out for number one. And in the case of Singapore, that's obviously Singapore and Indonesia. So there, you know, there is a lot of engagement between the private industry and the regulators. But at the end of the day, it's in many of these countries, like in Singapore, you may be a private company with a good idea, but if it doesn't fit with Singapore's agenda, then you might as well shelve it. So maybe I'll stop there.
Thanks, Zennon. That was helpful. You know, being in the region, it's particularly useful because many of these countries, you know, the Indonesias, the Indias, et cetera, these are, I mean, they might be ancient civilizations, but they're very young, modern countries. And the first thing, just in theory, is you jealously guard your sovereignty. And you first need to get comfortable in your own sovereign skin, and before you can cede some of that power away. The digital revolution is happening at such a fast pace. They're trying to, they don't want to make major errors. They want to protect first, whatever that means, protection and securing means, before they start ceding some of that authority. And they don't want to be in a position where they've signed up to rules and then they have to work backwards because the rules works to their detriment in some ways. But at the same time, I thought your view was really useful in terms of how countries are using kind of the digital ecosystems from a governance perspective to kind of leapfrog. I mean, a lot of the things that they could not do bureaucratically, now they can do bureaucratically because they can leapfrog it using the digital medium, and that's useful. And this brings to a larger point, which you also touched upon, and I just wanted to hear your views on this, which is with regard to China. You know, all of these countries, their major trading partner is China, and we are having digital rules set by the US wanting to set digital rules for the region, and these digital rules need to sit presumably comfortably for them to also be able to engage in their China trading relationships, including from a digital perspective. And so they are looking out at both sides, both securing themselves and how to have unimpeded trade with as many important trading partners. And do you see that this is anyway a dilemma for them, or this is something they're figuring out at their own gradual pace as they're moving forward?
Are you speaking specifically about China and what they're thinking about it? Look, I mean, if you look at a lot of the trade with China, it tends to be it's very physical trade at the moment, which has been happening for decades, and the implications of data around that are relatively limited. From a technology perspective, I mean, China has obviously made it clear, both in terms of soft and hard technology, that they want to be largely self-sufficient within, greater China. And I think that really continues to be the key focus for them, the feeling that, there's enough domestic demand that even without, companies purchasing Huawei routers, there's enough domestic demand to be able to handle that. And with the economic growth that China, of course, is pushing, that would handle it. So I don't think it really worries them too much, because on the trading side of things, which is, represents probably 80% of what's going cross-border being the physical trade, again, the implications for data are not particularly high. And when we look at the digital economy, China, rightly or wrongly, has created itself as kind of a digital island. Obviously, when I was there, I'm only getting used to Twitter over the past 5 years because I never used it for the 14 years that I was living there, and YouTube and WhatsApp being blocked. It's a completely different environment, and I recognize that now coming down to Singapore. And I still have WeChat on my phone, but it's rarely used. And the people that are on WeChat don't seem to be able to use any other platform to communicate besides WeChat. The ones that are still in China and very much have this kind of insular view of what's happening within the country, both foreigners and locals that are there. So whilst China is obviously, as was mentioned before, following what's happening in these other countries and around these trade agreements, I don't think they're really worried about it right now, because until another country like Vietnam perhaps can match the economics of a China, it's a little bit more challenging. Now, I think when you look at particular countries like India and Vietnam, where you have more digital goods that are going cross-border in the form of development centers, especially in Vietnam, those countries are a little bit more important for any kind of digital focused data agreement, because there is quite a bit of information that's going back and forth. But I think much like many companies are looking for alternative factories outside of China for physical goods, many are looking outside of China for digital goods as well.
Great, thank you. We have half an hour, a little under half an hour. Let's get into the discussion phase. I'm happy to have even the panelists throughout points and to each other. We have some questions. I'll get to the questions. Can I just to kick off the discussion again, Zennon, can I come to you with regard to in Southeast Asia? You talked about China and this digital island, and part of it is breaking out of that, and they are making, Chinese companies making investments in Southeast Asia in the digital sector and in payments and in those areas. What is the modus operandi? What is the game plan? Is it to become a very dynamic, huge player out there? And is it to import some of the regulations which are there in Southeast Asia, because most of their presence is I assume, in Singapore, or just have a big footprint out there so that they will necessarily have to be accommodated one way or the other? What is the Chinese game plan in, say, Southeast Asia, considering that they're basically kind of shut out from a variety of Western markets in some respects?
Yeah, I think I'd probably pocket that in two different areas. One is like pure technology, and the other being fintech. I mean, for probably over a decade now, companies like Ant Financial have been pushing into Southeast Asia to try and capture market share. And when domestically things were getting so competitive, obviously, you have to look international for expansion. And they've really struggled to really make hay in a lot of these countries, and even within the region. I mean, you have examples of technology companies like Grab as an example. Largely a Malaysian, Singapore company, and they've struggled to get traction in Indonesia, just because each of the markets is so localized, both in terms of culture, habits, regulations, and everything else that are preventing them from doing that. The one company that's done very well in expansion around the region is ByteDance, and particularly with TikTok. That somebody gave me an example of India, where you can have two towns that are 1 kilometer away from each other, and if you look at TikTok on a millennial's phone in one town and TikTok in another town, the feeds are completely different. And that could largely be said with us as well, but I think that with us, there'd be commonalities in terms of politics or challenges or whatever it is, but the algorithm is so strong that it's been able to localize itself so much to local industry. And because it's kind of purely an app and technology, the regulations and the hurdles that they've had to go through are not particularly high. So I think the Chinese companies, when it comes to fintech, which is probably the most obvious way that they've expanded internationally, they've struggled to really get much traction. But then ByteDance would be the exception on the technology side, where they've managed to really grab a significant, well, I wouldn't say grab significant market share because it's kind of a unique area, but to really capture eyeballs in these markets.
Sure, thank you. Susan, can I come to you with a question? You've done very pathbreaking work in the area of AI. Now, suppose you were asked to be in the negotiations and you are asked, like, how do we frame regulations, I mean, international rules on something like AI within the perimeter of a trade agreement? How would you proceed just from a point of theory itself, because everything is so dynamic? And what would you do in this regard if you had to set down rules?
I have a whole PowerPoint on this.
Please
Do you want me to share it? No, I don't want to take the time to.
No, please. We have time. If you want, I'm glad to sit minutes if you want to.
Okay, I have to open it up, but
Fair enough.
I do have a listing of the barriers that need to be addressed and some suggestions, but you know, basically, okay, I think I've got it.
I'm going to ask this thing to, if you could share the screen, and I don't think that should be a problem.
Well, I don't want to take other people's time, so I'll just show 2 slides, time from other people's thoughtful contributions here. But here's a listing of can you see?
Yeah. We're seeing. I can see.
Okay, so current rules don't address standards. So this whole bullshit about trustworthy AI, trustworthy AI could be a violation of like product, because does that mean that it's produced in a way that is different, but it is essentially the same product as untrustworthy AI? That's number one. Number two, it doesn't advance data sharing. And if we could anonymize personal data, and that's a big if, people have been trying for a long time, since 1997, to effectively anonymize personal data. And we have not been able to do that because even with one piece of personal data, like the last 4 letters of your last 4 numbers of Social Security, a good hacker can figure out who you are. But the problem with AI is a problem of collective data. And so we've got to figure out ways to anonymize, to protect, and then advance data sharing. So what do I mean by that? I mean data sharing among societal entities, so government, civil society, individual researchers, etc. And that's really important. Another thing we need is competition policies, shared rules to govern the behavior of companies that may use AI in unethical ways. One example of an unethical way is to to copy data that is not yours to copy. Web scraping is how, most generative AI companies have gotten a ton of data. And then they don't address questions of liability. Here's some of the trade barriers. So an example of a trade barrier, I talked a little bit about the right to, under US trade agreements, you cannot put in place a performance requirement. You cannot say that we need to see this algorithm if it is proprietary, except under the exceptions. And that means that GDPR, which offers individuals a right to an explanation, they can demand to see the algorithm that made decisions about them. And so I don't think the exceptions are the way to go with this, but that is a big issue. Another one is trust. But here's one more for you, and then I'll shut up. So first of all, you may have heard that one generative AI model, ChatGPT, passed the bar exam. So could ChatGPT offer legal services to people in Singapore based in the United States? That's going to be a GATS question. Another one is, how do you deal with AI generated products or services? Does the AI get credit for that? So we're in a period of governance experimentation. There's been a lot of bans of ChatGPT. There's been new approaches to regulating, and we don't know the trade implications of that. And I just think, on one hand, you want to encourage flexibility, but you want it to be binding and disputable. And why is disputable important? I know I said this before, so forgive me, Stephanie Honey, for but this is one of the things I learned from trade expert Stephanie Honey is, it's important that it be disputable because that provides clarity, right? Through trade disputes, we learn about how the exceptions or how the rules really work. Unfortunately, there's been very few trade disputes related to data. So we end up with this panoply of agreements that are essentially a spaghetti bowl of agreements, and they don't always intercept, and that is not helpful to anybody. It raises the cost to everybody. So what do y'all think?
Patrick, would you like to jump in out here? Simply because you talked about AI is right at the forefront, where it's like having rules, cross-border rules are so difficult, because at this point of time, in just plain vanilla digital trade areas, we are seeing how, from a competition policy perspective, there are very different approaches in the EU and in the US. And so, I mean, how do we square the circle, and what are your views going forward?
If I knew, I think I would be a wealthy person. And this goes back to what Zennon was saying, that we're all kind of struggling around this. It's a little bit like the new version of the Holy Grail, that we're all looking for it, but we can't find it. And certainly, it's difficult. It's even in something like AI, which is obviously developing very rapidly. We forget now that what is it? 6 months ago, no one had ever heard of ChatGPT, and governments themselves are struggling to, as Susan mentioned, there are so many things that we're still trying to understand, define, even definitions, and then from there defining certain standards to protect obviously consumers, to protect individuals in terms of their data, competition, which you mentioned. And then, we're not even talking about cross-border when it comes to that. I mean, certainly we've seen it with ChatGPT, where, certain regulators, data protection regulators, notably in Europe, like in Italy, put a stop to it and prevented access because of concerns about protecting individual data, personal data. And this is just going to keep going. And then there's the issue of, okay, how do you protect the consumers while at the same time, and in a way, we're going back to the story, how do you allow kind of the free trade to take place and free flow of data while ensuring that you're protecting individuals, businesses, intellectual property, if you want, or source codes and all these things at the same time. And to me, in an ideal world, obviously the way to do this is we all agree on what the on high level international standards, or high quality international standards, and within the everyone that agrees with those standards and implements them and is seen as doing it effectively, well, within that, obviously we can flow data, we can share AI services, all these things can happen. The problem is that we're far from even being able to do this even within countries that you might say are very similar, whether the United States and Canada, where Canada is not necessarily going in the same direction as the US. The US is struggling to define its own rules on these things, right? The states are moving on their own because the federal government is not able to. And then, how do you go from there, not knowing what you have nationally, to saying, okay, well, this is what we're going to do internationally, and this goes back a bit to what you were saying, Saurabh, where, countries are, we're talking about Southeast Asia and in a way, younger countries, if you want to say that, not necessarily true, but, kind of trying to find their ways and protect what they're developing. But the same thing is true for a country like Canada, for instance. We're feeling our ways, trying to find ways to kind of keep flowing data with the European Union, but at the same time satisfying commitments we've taken under the USMCA with the US. And everyone is trying to somehow circle the square, because in this case, I'm not even sure we're talking about squaring the circle. It's almost the other way around. You want to make it smooth, comprehensive, etc. But I think it's because it touches not just on the economic aspects, as I mentioned, but it also touches on fundamental elements of our society. It's not just about the economics. This is about public safety. It's about national security. So it's about individuals' privacy. These are fundamental elements that obviously people look to their governments to protect, right? At the core, we want to feel protected. We don't want to feel that our individual security, safety is at risk. So governments feel that and they have to respond. But how do you respond in that way while at the same time kind of sharing sovereignty? And that's really the challenge, as I mentioned it. And this goes back, to me, as I said, it's been my interpretation of Susan's catch-22. And AI seems to amplify that even more.
Yeah, great. Perhaps that's why part of the way folks have moved forward on this is, like the Singaporeans and the Australians and all, they've done it in that modular approach where everything is in small modules, and perhaps ostensibly each module can move forward at its different pace depending on how our rules shape up in that area, rather than, because otherwise it's hard to deal with this problem, because it just looks like, where do you start and when do you end? And you have to break it down into small modules, and hopefully you can get a little more sense in that thing. I see some questions which I want to throw out to the audience, but before I get to the questions, I had one more question for Patrick. Patrick, if you could just, you talked briefly about developments at the WTO in the e-commerce negotiation. If you could just keep us updated as to what you see where that negotiation is at.
Well, thank you. We're told, and Susan mentioned it, in a way, things are moving forward and there's progress. But, again, what is progress? How do we define progress? Is progress towards an agreement? That seems to be the case. But then what does it take to achieve that agreement, right? So in a way, we're back to this question as, do we incorporate into an agreement so many exceptions and so much flexibility that ultimately you devoid it of any teeth in terms of facilitating, international digital trade. And certainly the first text that was leaked now almost 2 years ago, indicated that yes, the broad principles are there in terms of non-discrimination, in terms of making sure that you don't favor your companies or at the expense of other countries. Those things are there. But then once you start looking at these exceptions, whether it's for national security or a legitimate public policy objectives, which you find, and then there was even language, because obviously you could see which countries that put what language in terms of, I remember there was something proposed by the Chinese, which was, and you find also in RCEP, which is, we'll decide what national security is, and that's clearly stated that no one's going to tell us what it is. It's basically every country is going to decide, that they can implement whatever rules they want to protect their country. That's a pretty broad exception, right? Because as we know now, national security seems to be defined in more and more broad ways, right? We just have to go back to the Trump administration determining that steel and aluminium from Europe and Japan or the US was a threat to, Canada was a threat to US national security. So, and so to me, when I see that language, and it goes back even to what I said about the Indo-Pacific Economic Framework, is that, yes, you'll reach an agreement, you'll get everyone on board, because ultimately people, countries will say, yeah, I can sign on to them because ultimately it doesn't really constrain me. So you have an agreement, great, but does it really achieve anything? Not so sure. Now, again, do we see that as a first step? We have an agreement. And then that creates the basis for, the next round of negotiation where, slowly you kind of ratchet up. But, that happens over decades ultimately. But maybe it's better than having nothing at all, right? At least it's a first step. So maybe that's kind of the optimistic way of looking at this.
Thank you, Patrick. I see questions out here. I'm going to merge two of the questions. It says the question is for Patrick, but I'm going to ask this question to all three panelists because I think it's an interesting one. I'm going to go first to Zennon, then to Susan, and then to Patrick. And the question is essentially, and I'm going to merge them, as China, the EU, and the US all launch their own policy initiatives in the digital space, what's the role and position of third countries and middle power countries? And let me also throw in the developer. How can developing countries in that process participate and benefit from these tensions between these countries? So it's these third guys out there in the mix, developing guys, countries too, and we see so many of them in IPEF particularly. What are your views? Zennon, why don't you go first on this?
Yeah, I think there is significant opportunity there, but it's how to take advantage of it. As I mentioned before, I mean, a lot of these countries are very domestically focused, and outside of one of the beauties of the EU is having a common regulator and a common currency that allows you to do a lot. Southeast Asia has none of that at the moment, and so it becomes much more challenging to come to agreements around this. So I think, whilst there is opportunities there for individual countries to, increase their status through some of these agreements, I guess it comes down to, again, what the agreements actually are accomplishing, right? They're just doing it for the sake of doing it, or do they actually have teeth and meaning and potential impact? So I think that's kind of the challenge with this is. And the other thing is just the sway that China has over many of these countries as well. I'll be going to the Solomon Islands in the beginning of June, and that's obviously a country that's been deeply going both ways on its relationship with China around various different geopolitical and economic issues. And that's the challenge, right? On one side you have the elephant that's in the room, and then you have the elephant that's on the other side of the ocean, and which do you want to tie your cart to?
Susan?
For developing countries, in a sense, this reminds me, I went to UNCTAD in, I think it was 2017. And I remember Nigeria, Egypt, and a couple other countries got together at the direction of Nigeria. And Nigeria, has about 200-ish million people, so it ain't a small country. But I remember they were saying that they should be able to move the data giants. And especially if they banded together, they could. But again, if that was not a binding free flow of data or a binding approach to how data would move among nations, they wouldn't have much clout. And honestly, I feel the same way about the US's little piddle agreements. Ultimately, given the amount of data in the world, as well as the number of people, small countries really don't have that much clout. And that's one reason why I always thought they should be more involved as part of the joint statement initiative on e-commerce at the WTO, because that is where they have leverage if they band together. And yet they have not done that. That's one approach. But the thing to keep in mind is that technological development is fluid. And it is quite clear that the US and China have comparative advantage in the data-driven sectors, an advantage that is because of network effects. And I'd be delighted to explain what that is, but that is an advantage that they have the biggest companies, the most data, the most variety of data at global scale, the fastest computers, the best AI research and XR researchers. So they have huge advantages, and yet they can be totally driven to pieces to use an idiomatic expression, when a technology changes. And I just cite as example, OpenAI, a small, albeit well-funded company, with funding by Microsoft, has been able to totally change the game on AI. So developing countries, if they really invest in their people, if they see data sharing as a way to foster innovation while protecting personal data, they could do comparative advantage leaps. And we see this to some extent in Singapore, a small country, but actually the country that I think does more to innovate in terms of digital trade. Language, partners with Australia. It's now got this Singapore UK digital trade agreement, you know? So I think things can be done. Chile's another example, although honestly, DIPA is out of date too. And that's where Chile led.
Patrick, before I come to you to give your final views on that, let me also throw that last question to you. Slightly different question. And you know, the question is, I'm going to add to the question a little bit out here. The question is, how will the new Chinese national security law effective in July, which law is that? Anyway, now China's national security law affect digital trade? How significant will that law make? But let me instead add more to this question. And the point being, you know, China had national security law, cyber security law, then went to data security law, personal information protection law. The EU has got, and so they're dealing with security, commerce, privacy. The EU did this with regard to GDPR, DSA, DMA. One question, of course, the previous question was about third parties, smaller, the middle countries. But my question out here is with regard to China, given the kind of parallel movement of Chinese laws, as many of them inspired by the EU, can the Chinese and the EU ecospheres be interoperable at some point of time?
In words, possibly. I mean, certainly in terms of protecting personal data, China has inspired its own laws on the GDPR. I think the issue, as Susan stated, the main issue with China is these things don't apply to the government, right? And as we know, the reach of the government into businesses, into the economy is very large. So obviously, you know, there is always, from an EU perspective, to say, okay, if we allow, we can say, okay, yes, the law itself on protecting data or personal data is similar to ours. So potentially we could, you know, in a way, allow the personal data of EU citizens to move easily to China. Then the problem is that after that, then there are these other laws that apply to the government. And then, yes, maybe businesses themselves are compelled. And again, we have to see how effective the implementation of the private side of it. But the problem is really on the public side of issues. And obviously, as we know in China, this is much more meshed and integrated than in Europe, for instance. So I think that's the main challenge is you know, and certainly given the current tensions that exist, you know, between obviously Europe and China, the US and China, any sort of deal or recognition that, you know, the EU would give China, I just don't see it in the current geopolitical context that happening. I think that's the main issue because, you know, my reading of what's happening in China is that the cybersecurity law, the national security laws, and all these things kind of supersede anything that could happen within the private sphere, within the business, the commercial sphere, right? And it's not like, oh, there's one for the government and there's one for the private sector, and I think that's what makes any kind of convergence. You know, internationally, to go back to what Zennon was saying, oh, well, if we have international rules, China has to be part of them. I just don't see in the current context, you know, how we could get the EU, the US, Canada, you know, to agree to a deal, an international deal with China, unless, yes, it happens at the WTO into this kind of trade-related aspects of e-commerce agreement. but where anything goes in a way, right? Yes, we agree, but we agree that we're all have different approaches and we're all going to do what we want. Okay, fine. That's possible. The EU has followed that model. As I said, if you go back in time, a lot of the first directives that were adopted by the EU in a variety of fields, often kind of basically set in supranational law the national standards. Basically, we agree that what happens in Germany, what happens in France, what happens in Italy is fine. So we have a common directive, but we respect the fact that things are different. But then it starts forcing conversation as to how to harmonize this, and reduce the gaps between all these things. So as I said, maybe that's the way we need to look at this. And for small, to go back to the middle countries that are stuck in the middle, obviously, the worst thing for them would be to be forced to choose, whether it's choose the Europeans, choose the Chinese, the China model, or as Susan and I call the realms, or the US one, right? And right now they're playing kind of on all these fronts, because for many of them, they don't want to be forced to choose in order to continue doing business. And we see that with IPEF. As I mentioned, a lot of the flexibility in those agreements reflects the fact that the US is not forcing them to choose particular rules. In a way, it kind of respects that in order to say, hey, let's continue talking and I keep you close. I'm not forcing you to just be in my little sandbox, but I want to play with you in the sandbox so that we're friends, but that's fine. You can still continue going in the Chinese sandbox, if you will, and we'll find ways to make that happen. I just don't want you to just be in that China sandbox. I want you at least to be kind of spend more time in my sandbox than in the other sandbox. And maybe over time, you'll find that you want to spend even more time in my sandbox than the other sandbox. And finally, what we see is the Singapore model, right? Where Singapore is really kind of, as a very small country, but obviously dependent on international trade, trying to push even on its own, like being members of these things, but also kind of maybe pushing its own principles, like it did with the DIPA, even if, with Chile and New Zealand, maybe with modular aspects, kind of in a way, not obviously try to influence things because of economic size, but maybe with solutions, with ideas. And maybe that's the way that those middle countries can have an influence and say, hey, I have this idea, this solution that actually might work for a larger number of countries. And because I'm a member of all these forums, or agreements, I can bring it to the table and try to have influence that way.
Fascinating. That was a great answer. And I mean, it kind of encapsulates this discussion of how countries are moving forward. And also on that China point, I think it's absolutely taken, because, where Privacy Shield ran afoul was that there wasn't an independent authority to which, on the US side, to which the EU felt confident in. And if that be the case, I mean, the EU will need to have far greater confidence in China's judicial system before it's going to have that sort of data sharing, data exchange. Anyway, we've run out of time, but this has been a fascinating conversation. Thanks to all the panelists. I think this year's IPEF, the digital trade chapter, will be very interesting, because what we discussed out here, in the United States, there's a head of steam building up in having rules on privacy with regard to moving the ball and antitrust. And so that clash of domestic regulation and international rules has really come to the fore at this point, perhaps a little unfortunately for USTR, but they have to cope and deal with it. And we'll see how they do it. And it will perhaps set useful precedents. And I think it's a fascinating time. But thanks to all the panelists, to Susan Aronson, Patrick LeBlanc, and Zennon KAPRON for a fascinating discussion. Hope to catch up with you all again soon on a similar topic later. Thanks to everybody who participated.
Thank you very much. This was a great discussion. I learned a lot. Thank you so much.
Yeah, Rob, you did a really good job of a very tough topic, given that it's so vague. Thank you. I really am impressed with your moderation. Nice to see you all.
Thank you, Saurabh, and thank you, Nong.